Actually, I'm Walter Pierce, but I have Bill Bond with me, and we're going to talk about wills, estates, trust, the planning that you should do if you own real estate or if you're going to own real estate, and probate. So, Bill, I guess we could even title this probate. Is probate a bad thing?
Well, it's not really a bad thing. It helps to transfer title to property that somebody owns after they've died, and now the property goes to whoever their beneficiaries are. And the process of accomplishing all of that is called probate. It's pretty simple and
Why do
fun.
so many people say how bad it is, and it's just like they want to avoid it at all costs?
In some states, it is a very um, difficult process and therefore one you want to avoid. Florida is not one of those states. Just the same, if you can arrange your affairs to avoid probate, you do save some expenses that are associated with doing it. So why not take those steps?
Okay, perfect. Thank you. A lot of our clients find themselves in a situation where they have found they own property and they want to know the best way to get to liquidate that property. Obviously, we can show them what it would be like to hold that as an asset, what the benefits are, how long they may or may not want to do that. But in this case, let's just say they want to get rid of the property, so they need to make sure they have like a clear title and or marketable title.
That's right. And if you're asking about how probate plays in that role, the probate process is what allows the property's title to be passed from the person who just died to their beneficiaries so that those beneficiaries can then sell the property. Or also, there's a possibility that through the probate process that the person who's administering the estate, that's appointed by the court to administer the estate, they might be able to sell the property. Just depends on the circumstances and the operative documents.
So tell me this, on a horror story level, I mean, since this is a short interview and you've got things to do, go ahead and tell us what can happen if you don't plan, and what can you save us if you do plan?
So I have a client right now that I'm representing. She lives out of state. Her father died here in Florida, down in South Central Florida. And he had told her over the years that he was leaving his entire estate to her. She's the only child. And he had remarried, and he and his new wife had made a prenuptial agreement, meaning she had waived all of her rights in his estate, and he did likewise in hers. And so the husband, now deceased, um, and also father of my client, had told my client she was going to inherit everything. So big surprise when after his demise, we discovered that when they bought their house in Florida, they being he and his wife, they had both their names put on the deed. Well, that means they co-owned that property. And in Florida, to make matters worse, because they owned it and acquired it while they were married, Florida law presumed, and does presume for all similar cases, that they meant to take title as something called tenants by the entireties, which is significant in a number of ways, but one of which that's important in this case is whoever is the survivor of that married couple becomes the sole owner of the house or the property that's titled that way just by virtue of surviving. And all they have to do is put a copy of their deceased spouse's death certificate into the public records, and that acts as a conveyancing instrument to confirm that they are now the sole owner. So my client was surprised because her dad had told her all these years she was going to have the house along with everything else. And then lo and behold, he had put title in both his name and his wife's name. So now the wife owns that house and not his daughter as he intended, apparently.
Um, what what can somebody do ahead of time if they think they're going to inherit something? Can they bring their grandparent or their parent in to see you and look at some options? And how much does that cost?
Yeah, well, certainly reviewing everything in advance allows you to take remedial measures if something's not like it ought to be. Um, if you wait till the ancestor is deceased, it's probably going to be too late. So the time to act is while they're alive and have their capacity and they're willing to do what needs to be done. In terms of cost, it just depends on the lawyer that you consult and how they charge. Some lawyers charge fixed fees and some hourly fees. I tend to charge an hourly fee.
That's great. That's great. And I know you've saved a lot of people a lot of angst and money. So their fees are great. I know you've helped a lot of my clients and a lot of my buyers and sellers. We get to this point, whether it's ahead of time or after the fact, and we still need to get that property and maximize what they can do with it. We come to you, and you can put that together. Now, you also have a title company that you can send stuff to, right? You
That's
own,
exactly
or
right.
you have an interest in a title company.
Yes, Pensacola
That
Title.
allows you to do some more stuff. Tell us about that.
Yeah, so we're associated with a title company that we can do a lot of the real estate work, and then we hand the ball off to the title company for them to do the loan closing, the sale closing, whatever the transaction may be that's a closing regarding the real estate
Okay,
issue. So
so that's awesome. The whole ball of wax. Okay, so when it comes to, I want to make sure I don't miss anything. We've talked about probate. We've talked about planning. I guess we should touch about the actual will and a trust. If a trust document is necessary, and any estate planning, because I know you're an expert tax estate planner, which is kind of a super special study that's pretty impressive. So if you could explain those to us, that'd be great.
sure. So a will is the document that you make that speaks for you after you're deceased. And it has to be made with certain formalities that are required by law in order for it to be a valid will. So once you are deceased, your beneficiaries or whoever you've named to administer your estate might offer that document to the court and say, Judge, this is the last will and testament of the decedent. And then the court has to determine, is it in fact a valid will? Was it made with the correct formalities of law and so forth? And if so, the judge does something called admitting the will to probate. That just simply means now it's being recognized legally as your will, and it speaks for you as to who should receive your property. A trust is a legal relationship, and it's a contract. It's a contract between the person establishing the trust and the trustee with a third party beneficiary of the contract, which is the beneficiary of the trust. And so, what the person creating the trust is doing is they're making a contract with the trustee. Please hold and administer and manage this property for the benefit of the person that I've designated to be the beneficiary of the trust. So, it's really a pretty simple arrangement when you think about it. It's just a contract, really.
Good.
And trusts can be established in your will, or they can be established by a separate legal document, a trust agreement. So you can establish trust through a number of in a number of ways in a number of instances.
Okay, that's awesome. One of the things I wanted to ask you, last thing I want to ask you is, when you're in the grocery store or walking down the street, what's the number one question you get in regards to your business and how you help people? What's the number one question you get?
Well, everybody asks what's pertinent to themselves. But definitely a question that comes up from time to time is, do I need a will? Do I need an estate plan? And I would say the answer is yes, you need a plan. And that would be called your estate plan. It may involve making a will, it may involve making a trust, it may not involve doing either of those things. It may involve setting up a bank account that is payable on death to a particular individual that you want it to be paid to. It might be making sure your beneficiary designations are correct on your retirement plans and your life insurance. Or it could also be handled by making a deed for a piece of property you own to whoever you want to receive that property at your death, and then maybe you reserve something called a life estate to yourself. The point I'm trying to get across is there's so many different tools in the toolbox that we can use to plan someone's estate, and it's not a one size fits all.
That's awesome. And now let's talk about size. How big are some of these estates that you handle?
Well, I handle estates that are from anything from a few $1,000s to upwards of $100 million. And it just really comes down to everybody needs to be a good steward of what's been entrusted to them. And making these kinds of plans is part of being a good steward. So
I like that. That's good. We're going to end on that. Well, Bill, thank you so much for your time. Have an awesome day. I look forward to seeing you very soon.
thanks, Walter.
All right.